I'm going to be talking to Chris Samuel, who is the president of the Canadian Bar Association's Alberta Branch, about the UCP government's decision to introduce the Back to School Act and then use the Notwithstanding Clause in the Constitution to prevent judicial review of that. It's very, very controversial, and looking forward to getting a lawyer's take on this. So welcome to the interview, Chris.
Thanks very much, Markham. I'm happy to be here.
Before we get into the nuts and bolts of the discussion, could you give us just a very brief overview of what in fact happened and why it's important?
Sure. So the Notwithstanding Clause is an instrument that is part of, as you say, Canada's Constitution and specifically the Charter of Rights and Freedoms. So Section 33 contains a provision that allows the government essentially to pass law, notwithstanding that it overrides or infringes on other parts of the Charter. It's not all parts of the Charter, but Section 2 and then Sections 7 to 15, which contain things like the freedom to of expression, the freedom of religion, equality rights, right to life, liberty, security of the person. Those are some of the rights contained in those sections.
So basically, once it's invoked, and it's right in the legislation, so that's how it's invoked. Then it can't be taken to court, and it can't be challenged by the union or by individual teachers. So why is this meant to be an extraordinary measure and it's only been used very, very seldom, but why is it meant to be extraordinary and used seldom?
So that's a great question. It is certainly extraordinary. You've mentioned that it's seldom used. I guess what I'll observe to start is that we've seen it invoked more frequently, not necessarily by the Alberta government, but across the country, you've seen governments more willing to resort to the Notwithstanding Clause. Examples out of Ontario and Saskatchewan and Quebec show us that this is increasingly being used. So I think what I can say is that the Notwithstanding Clause was originally put in to the Charter as a compromise. There were a number of provincial premiers at the time of the Charter's passing who were concerned about ceding too much authority to the judicial branch. And so as a compromise, the Notwithstanding Clause was put in on the theory that the elected legislature or the elected parliament should have ultimate and final say over whether something goes into law. And so if you think about sort of the structure of the Charter, the structure of the Charter of Rights and Freedoms, you have to remember that Section 1 contains a reasonable limitation. That's built into the Charter. It'd be a mistake to think that charter rights are absolute. They're not. Section 1 says that those rights can be infringed, but they have to be demonstrably justified in a free and democratic society. So there was a thinking at the time that it might be the court drew the line of what's reasonable in one place, and an elected government would have drawn the line at another place. And so when it's a competition between those two branches, Notwithstanding Clause was enacted to recognize that it should be the legislature that holds the final say.
I had a guest on, I think it was Jason Foster, Professor Jason Foster from the Athabasca University, and he made the point that the Notwithstanding Clause was meant to be an exception, and it wasn't to be used by governments for political convenience. So, you've got striking public workers, and it's inconvenient to you because there's political pressure on the government to get this resolved. And you don't want to do that, so you just invoke the Notwithstanding Clause, and it's kind of like a get out of jail free card. And why is it dangerous if we normalize using the Notwithstanding Clause?
Right. So I guess a couple observations. First observation is that there's actually nothing in the text of the clause itself that restricts or prevents a government from using it whenever they feel like it. Um, it can be used after the court has ruled legislation invalid. It can be used before legislation has been passed. Those are all legal uses. But the concern that the Bar Association has, and the concern I think that you're articulating here, is that when you use this, when you normalize the use of the notwithstanding clause, it reduces the protections afforded to Canadians, to Albertans, by those sections of the Charter that I think most people really value. We really value having freedom of expression, freedom of religion, equality rights. Those are all things that are core to the Canadian identity. And the notwithstanding clause allows governments to get around those protections.
So I guess the argument here, excuse me, is that today it's teachers, tomorrow it's religious groups that the government doesn't agree with. Then it could be business owners, could be minority groups like trans groups or gay groups. But once you get on that, it becomes a slippery slope. That's the problem?
Well, again, whether or not it's a problem is ultimately that's a decision that the voters are going to have to make. Again, I stress that it's not illegal to use the notwithstanding clause in this way, but but it might create a situation, in the future with a different government, with a different set of policy priorities, where all of a sudden, if it's been allowed to be used in this way without any sort of um, issue from the voters, then yeah, I think there is a concern that you're going to see it used more frequently in Alberta and across the country.
Yeah, I mean, that to me, that's the logic of it. I mean, once you normalize it, then you allow governments to weaponize it if they choose so.
Right. So I guess the observation I'll make is this talk of weaponize. Again, that's an evaluation I think that the electorate is going to have to make. Whether this is a good use of the notwithstanding clause or a bad use, that's almost beside the point, and that's got to be decided by the electorate on a case by case basis. The ultimate accountability mechanism for a government's use of the notwithstanding clause is to be answerable to the electorate at the ballot box. And so that's why in the architecture of the notwithstanding clause, you have a 5-year limitation period. The thinking being that if a government uses it in a way that is unpopular or contrary to what the wishes of the electorate are, they'd be punished for that at the ballot box.
Well, let's move on and talk about the judicial review that should have taken place. And why is it important that the government should have been forced to take this before the courts to determine whether it was a legitimate use of the notwithstanding clause?
So what I'd say to that is, again, I want to stress that it's not a requirement that's found in the notwithstanding clause to have a court rule on the legislation beforehand. But what we know from history and what we know from Peter Lougheed, who was instrumental in having the notwithstanding clause as part of the charter, is that it wasn't designed to be used in that way. And in fact, when Quebec began using it preemptively, there's good evidence to suggest that was Premier Lougheed was pretty offended and shocked by that notion. He was not a fan of that approach at all. And so the reason I say that can be problematic is because when you go to a court to try to justify your legislation, you've got to do that on the basis of legal argument. You've got to do that on the basis of evidence. And there's a possibility that the court is going to say, you know what, government, you've passed a law, and we don't find that there was a reasonable justification for this law. But it's equally possible that a court would look at the legislation and say, yeah, here were some really extraordinary circumstances. The government's got a good justification for doing what it's done, and it would allow the legislation to stand. So, so that discussion, that public debate, when it happens in a courtroom, I think it gives some transparency and accountability to that lawmaking process. Why are we doing this? What's our justification for it? But if you're invoking the notwithstanding clause preemptively, you circumvent that democratic discussion, and that's the issue. Um, I guess one more thing that I'll say about that sort of court process, there is some thought that a union or somebody who's been affected by a law where the notwithstanding clause has been invoked might still be able to go to court and ask for a declaration. I don't know whether that's true or not. The Supreme Court of Canada is going to rule on that. I would imagine within the next 8 months or so. But it is a live argument and it's a live debate in legal circles.
The last point here is that you're concerned, the Canadian Bar Association is concerned there wasn't any debate inside the legislature. The government limited debate to an hour for each one of the first, second, and third readings. And why is that important that that not be the case?
Right. So I think I've said this already in the interview, but the ultimate accountability mechanism for the use of the notwithstanding clause, that is with the electorate. And when you have a situation where a government is seeking to use the notwithstanding clause, you've got to give time for voters, constituents to review the legislation, understand what it's doing, to write to their elected representatives with concerns, and and that takes time. That takes energy. It takes the effort from the lawmakers to listen to their constituents. And that's really, I think, how the notwithstanding clause was designed to be used to give that accountability mechanism to the electorate. And you can see that in Alberta's history. There was a law that was proposed in 1998 where the government intended to use the notwithstanding clause, but that bill never made it into law because there was enough of a public outcry that the government didn't ultimately pass that bill through third reading. It didn't go all the way. Um, so when you have all three readings in a single night, you're not giving the democratic process enough time to work itself out, and that runs contrary to the spirit of the notwithstanding clause.
Well, Chris, this has been very insightful. Thank you very much. Really appreciate it.
I'm happy to have the discussion. Thanks for having me.